5 seconds to go. Start. The High Court in criminal revision against conviction is not supposed to exercise the jurisdiction alike to the appellate court, and the scope of interference in revision is extremely narrow. Section 397 of Criminal Procedure Code vests jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality or propriety of any finding, sentence or order recorded or passed, and as to the regularity of any proceedings of such inferior court. The object of the provision is to set right a patent defect or an error of jurisdiction or law. There has to be well-founded error which is to be determined on the merits of individual case. It is also well settled that while considering the same, the revisional court does not dwell at length upon the facts and evidence of the case to reverse those findings. This court in the case of Manju Ram versus State of Assam 2019-13 SCC 330, while dealing with the scope of reappreciation of evidence by higher court in criminal revision, observed in paragraphs 9, 10 and 11 of the judgment as under. So far as issue 1 is concerned, that is, as to whether the appellant got married with Srimati Ranju Sharma, is a pure question of fact. All the three courts below have given concurrent finding regarding the factum of marriage and its validity. It has been held to be a valid marriage. It is a settled legal proposition that if the courts below have recorded the finding of fact, the question of reappreciation of evidence by the third court does not arise unless it is found to be totally perverse. The higher court does not sit as a regular court of appeal. Its function is to ensure that law is being properly administered. Such a court cannot embark upon fruitless task of determining the issues by reappreciating the evidence. This court would not ordinarily interfere with the concurrent findings on pure questions of fact and review the evidence again unless there are exceptional circumstances justifying the departure from the normal practice. The position may undoubtedly be different if the interference is one of law from the facts admitted and proved, or where the finding of fact is materially affected by violation of any rule of law or procedure. Thus, it is evident from the above that this court, being the fourth court, should not interfere with the exercise of discretion by the courts below, as the said courts have exercised their discretion in good faith, giving due weight to relevant material and without being swayed by any irrelevant material. Even if two views are possible on the question of fact, we, being the fourth court, should not interfere even though we may exercise discretion differently had the case come before us initially. In view of the above, we are not inclined to interfere with the finding of fact so far as the issue of bigamy is concerned, nor the quantum of punishment on this count is required to be interfered with. As per the settled legal position, and after conviction by the trial court and the appellate court, On filing the revision, the High Court maintained the conviction, upholding the findings of the two courts. Stop.